Hello and welcome to the podcast of Center for Constitutional Law and Administrative Law. Today we will be discussing the office of the governor and its place within India's constitutional framework. Today's episode explores one of the most intriguing and often debated institutions in India's constitutional structure, the office of the governor. The Sarkaria Commission on Center-State Relations famously described the governor as the linchpin of the constitutional apparatus of the state. Despite being conceived as a constitutional head functioning largely on the aid and advice of the Council of Ministers, the governor's role frequently comes into public focus during moments of political uncertainty, whether in the formation of governments, the exercise of discretion, or the handling of legislation passed by state assemblies at times. To help us understand these issues better, we are honored to have with us today Mr. V. Sudhish Pai. Sir is a senior advocate at the High Court of Karnataka and a distinguished constitutional jurist with decades of experience at the bar. Alongside his legal practice, he has made significant contributions to constitutional scholarship and legal education. Sir has also served as the Ashutosh Mukherjee Chair Visiting Professor at the West Bengal National University of Juridical Sciences. He has also authored a number of significant books that cover the lives of the greatest jurists in India. He has also written extensively on several topics of Indian constitutional law and governance, and his writings are widely respected in both academic and legal circles. It's a privilege to have you here with us today, sir.
Thank you.
So the first segment of our conversation today is about the constitutional idea of the governor's office. And to begin with, the governor is often described as the constitutional head who operates largely within the framework of ministerial advice. Now, against this backdrop, I would like to ask this question to sir, that when it comes to the idea of constitutional discretion, which seems to lie at the very core of many debates today surrounding the office, what exactly is this idea of discretion that we talk about when we talk about the governor? Particularly because Article 163 explicitly provides that the governor may act in his discretion in certain matters. However, the Constitution does not explicitly say so in terms of the powers of the president. Now, sir, kindly let us know, how would you differentiate the nature of the discretion exercised by the governor from that exercised by the president within the constitutional scheme? And in particular, we are interested in knowing that what light do the Constituent Assembly debates shed on whether the framers intended the governor to possess a different or perhaps a wide sphere of discretion in comparison to the president. Over to you, sir.
Thank you. The office of the governor, of course, is considered as the constitutional head of state, but it is well settled that both the governor and the president at the center, their position is akin to the British monarch. It is essential to begin with that what we have adopted is a parliamentary system of government, where the real power rests in the Council of Ministers headed by the Prime Minister or the Chief Minister at the state level. You mentioned the Constituent Assembly debates, and I think I can do no better than quote Dr. Ambedkar when he introduced the draft constitution. And this is what he said on the 4th of November 1948. There is placed at the head of the Indian Union a functionary who is called the President. The title reminds one of the President of the United States, but beyond identity of names, there's nothing in common between the form of government prevalent in America and the form of government proposed under the draft constitution. The American form of government is called the presidential system. What the draft Constitution proposes is the parliamentary system. The two are fundamentally different. Under the draft Constitution, the President occupies the same position as the King under the English Constitution. He is the head of state, but not of the executive. He represents the nation, but does not rule the nation. He is the symbol of the nation. His place in the administration is that of a ceremonial device on a seal. Please mark these words. His place in the administration is that of a ceremonial device on a seal by which the nation's decisions are made known. The President of the United States is not bound to accept any advice tendered to him by any of his signatories who are in charge of different departments. The President of the Indian Union is generally bound by the advice of the ministers. He can do nothing contrary to their advice, nor can he do anything without their advice. And in the debate on Article 74, draft Article 61, the debate went on to say that the article should not be interpreted literally because they embody conventions of the cabinet system of government evolved in Britain as a result of a long struggle between the King and Parliament. And then Dr. Ambedkar concludes, there is no case which can arise where the President will be called upon to discharge his functions without the advice of the Prime Minister or his cabinet. Under a parliamentary system of government, there are only two prerogatives which the head of state exercises. One is the appointment of the Prime Minister, the other is the dissolution of Parliament. The position of the governor is exactly the same as the position of the President. This is what Dr. Ambedkar said. But of course, then we come to Article 163, which makes a slight difference where certain functions to be exercised by the governor in his discretion are explicitly mentioned in 163(2). And that negatives the whole idea, as Sirvai, with great respect, very rightly comments, the idea that the governor enjoys any general discretion. The governor enjoys no discretion. And let us never forget that the President, at least, is an elected head of state. The governor is not elected, and neither of them is accountable. It is the ministry that is accountable to the legislature and in turn to the people. So this is the bottom line based on which all interpretation of the nuances of the system have to be understood and given effect to. So it's only certain specific functions are assigned to the governor which he can exercise in his discretion. There is no general discretion. The general discretion settled by conventions is the appointment of the Prime Minister or the Chief Minister, and the dissolution of House, again, not always. The dissolution also has to take place only on the advice of the cabinet, except where the ministry has lost the confidence of the lower house. Then, of course, you also have, for practical purposes, certain functions which inherently would not be amenable to ministerial advice. If the sanction to prosecute a minister has to be given, the President or the governor would have to do it on his own. Article 356 report, the governor would have to make a report on his own. Necessarily, it can't be on the advice of the ministry. But these are well-known, well-defined exceptions. But certainly, there is no general discretion vested in the governor to disregard the advice of the Council of Ministers. And there's one passage 113 years ago, Prime Minister Asquith presented a memorandum on this to King George V. This has been quoted in the Constituent Assembly debates and quoted in the judgments of the Supreme Court. I think that passage brings out very clearly and emphatically the position vis-a-vis the ministry and the crown of the head of state. And this is what Prime Minister has been said. A constitutional monarch in this country is entitled and bound to give his ministers all relevant information which comes to him, to point out objections which seem to him valid against the course which they advise, to suggest, if he thinks fit, an alternative policy. Such instructions are always received by the ministers with the utmost respect and considered with more respect and deference than if they proceeded from any other cause. But in the end, the sovereign always acts upon the advice which ministers, after full deliberation and if it be reconsideration, feel it their duty to offer. They give that advice well knowing that they can and probably will be called upon to account for it by Parliament. This is the Constituent Assembly debates on the 2nd of June 1949. This brings out the whole purport of this position and the nuances of it very tersely. And if you proceed even further, we have an opinion after the working on the Constitution started. No less a person than Rajendra Babu, who presided over the deliberations of the Constituent Assembly, as President expressed doubts whether he should necessarily assent to the bills. The Hindu Code Bill was the legislation in question. He wrote a letter to the Prime Minister. This was referred to the then Attorney General Motilal Sittalwad and Sir Krishna Swamy, perhaps one of our greatest constitutional lawyers and a principal architect of the Constitution. And both of them unequivocally stated that the President is bound by the advice of the Cabinet and by the Prime Minister. Sir Awadi said that Article 74 is all pervasive. It speaks of no exceptions, and the President is not a revisional or an appellate authority over what the Cabinet decides. In fact, it's been picturesquely said by some English authors that while it is said that the President or the monarch acts on the aid and advice of the Prime Minister and his Cabinet, it is not that the Prime Minister advises him and the President decides. It's exactly the other way around. The President may may advise and give suggestions. The decision is always the Prime Minister. And to carry it even further, it has been observed by authors in English constitutional law that even if the monarch, even if his own death warrant was placed before him, the monarch has no alternative but to sign. That is the position. And any talk of governors having wider discretion, I'm afraid, is absolutely untenable, ill-informed, misconceived.
Thank you so much, sir, for taking us through the initial idea about the discretion, because I think this is a common question that arises every now and then as to where do we locate the governor in terms of the discretionary powers vested.
Sorry. In fact, in the Constituent Assembly, Krishnamachari, joining the debate after Dr. Ambedkar, said that honorable members will have no doubt and everything falls in its proper place if only you appreciate that the President and the Governor, of course that was particularly with reference to the Governor, has no discretion and he acts always on the aid and advice of the Council of Ministers headed by the Chief Minister. In fact, you would also remember that Under the Government of India Act, the expression "in his discretion," which was retained in the draft articles, was expressly done away with. And the Constituent Assembly, the Founding Fathers emphatically said that this is the intention, that in his discretion is taken away, there is no discretion left. Of course, except those fundamental areas where you have to invite a chief minister, it has to be, there's no government on whose advice you can invite who is to form the next ministry.
Thank you so much, sir. So this takes me to another important structural issue. As you've spoken extensively on the Constituent Assembly debates, and the Constituent Assembly debates, they kind of, contain a lot of discussions on why we will not proceed with an elected office for the governor. Instead, a nominated one, because the framers did not want a parallel administration in the state. Now, what we want to know is that do you think that the appointment mechanism and the fact that the governor holds office during the pleasure of the president, does this particular method raise any concern about the governor's institutional independence within the federal framework, particularly when discretionary powers are invoked in several sensitive matters? So what would be your take on this, sir?
As far as the first part is concerned, I think the constitutional mechanism is quite all right. The constitution makers did not want an elected governor, and certainly the constitution does not envisage two parallel centers of power. The governor is the linchpin and the link between the union and the states. Unfortunately, in the working of the constitution, there are certainly areas for concern. And I don't think we can have a better mechanism. It's only that we need better men. The answer is, as already provided by Ambedkar and Rajendra Prasad, if the constitution does not work well, it is not because the provisions are bad, but because man is wild. Man continues to be even more wild today. In general terms, this is the answer. Yes, there are concerns, there are areas of concern, because many times, unfortunately, governors, and this is a trend as we go on in more recent times. It was never the trend in the 50s and the 60s. And why? Because you had men, not men of straw, but men who had a caliber of their own. Not that they were flawless, no one is, we are all human. But today the flaws seem to be in such great proportion that to find what is good is like looking for a needle in a haystack. And the concern is this, that governors act not only as agents of the central government, but even more as agents of the party in power in the center. I'm not talking with reference to this party or that party. This has been the uniform pattern, at least for the last 3-4 decades, with degrees of difference here and there. But then we must never forget what Balkiwala said or Judge Learned Hand said, that you cannot look for legal solubility to all problems. As Learned Hand said, liberty lives in the minds and hearts of men. If it lives there, you need no constitution, no court to save it. If it dies there, no law, no court, no constitution can do anything to save it. That is the bottom.
Right, sir. So you made a very interesting statement here, particularly in relation to the governors that generally there's this understanding. And of course, the Honorable Supreme Court has also spoken along these lines in BP Singhal, as a word of caution, that governors should not act as the mouthpiece of the party in power. So interestingly, while addressing the frequent removal of governors, this question came up in BP Singhal, and that's exactly what you said. But as far as the courts are concerned, what we have seen is in BP Singhal, we see that the court extended the idea of judicial review to arbitrary removal and did talk about at length on this issue. However, at the same time, it did not press for a reason. It did not ask for a reason. It did not make giving of a reason compulsory either. However, retained the idea of judicial review. So in this case, what we are interested in knowing is that how do you think judicial review can be effectively carried out without a reason, without the compulsion of furnishing a reason, by the center?
I would think that Singhal's case is a very important milestone in our constitutional history and constitutional law. It is one of those cases where I think the court tempered the exercise of power with a constitutional culture. The court did not really say that that need not be any reason. If I am not wrong, what the court said is that you don't have to disclose the reason, but you will have to disclose the reason to the court in judicial review. You don't have to tell the governor what the reason is, if at all he is being sent home. But in judicial review, you will have to tell the court what the reason is. And the court also quoted 1967 House of Lords, which Justice Yashwant Chandrachud had quoted in the Rajasthan Assembly dissolution case, where the House of Lords said that if you have no reason and if you don't disclose, then the court would have to draw the inference that there is no reason or no tenable reason, and that itself would be sufficient ground for interference in judicial review. So Singhal's case has laid down the parameters, I think, quite correctly. But then how much of it is being observed, that it's not always a happy thing.
So here in BP Singhal, if I can just point out, in the second part of paragraph 50, it reads that though no reason need to be assigned for discontinuance of the pleasure resulting in the removal, the power cannot be exercised in an arbitrary, capricious or unreasonable manner. The power will have to be exercised in rare and exceptional circumstances for valid and compelling reasons. So if you could, take us through this understanding. So there's no compulsion for a reason, as the first line suggests. But again, it continues to read as the power will have to be exercised in rare and exceptional cases, circumstances for valid and compelling reasons. So while judicially reviewing this question,
the reason would have to be disclosed to the court when it goes into it in judicial review. The reason may not necessarily be assigned to the governor, but when the matter comes up in judicial review, the file will have to bear out some reason which is amenable to scrutiny by the court. And then, of course, depending on how the court accepts it, if there is no reason, that's why I said the court quoted the House of Lords. I forget the name of the case. It's one of those famous cases, 1967, which Chief Justice, he was not Chief Justice then, Chief Justice was Beg, with Justice Yashwant Chandrachud quoted in the state of Rajasthan, and that is quoted in Singhal's case. That if there is no reason, then the court would have to draw an inference that something is wrong and the action is not sustainable.
Okay. So we come to the idea of government formation and the judicial practice in these cases. So one of the most visible moments of gubernatorial discretion occurs in situations of government formation, particularly when election results produce a hung assembly. So we've seen in cases like G. Parmeshwara versus Union of India, where the governor's decision, to invite a particular political party to form the government was challenged precisely because a 15-day time period was given to prove the majority. And courts in these cases have generally refrained from entertaining or scrutinizing the governor's decision-making process. Instead, they've ordered an immediate floor test. So what are your thoughts about this approach of the judiciary? Do you think it is based on the concern for judicial restraint, or do you think it is about the idea of allowing the right institution to take up the question, and that is the legislative floor test? So what is your take on this, sir?
Judiciary is totally out in this case. It's none of their business who forms a government. In fact, all these cases where the judiciary has stepped in, with great respect, their decisions have been respected out of courtesy. It's none of the business of the courts as to who forms a government. It's our business. We the people and our representatives. The court steps in only when there is an illegality. Discretion, that discretion, I am afraid, is never amenable to judicial review. Ultimately, the discretion would have to be tested in the assembly or the parliament. And even there, now that you have asked me, the judgment of the Supreme Court ordering floor test is totally in violation of the Constitution, not for ordering the test. Sorry, ordering the test was perfectly all right. But what did they do? They ordered a floor test where there was no floor. You could have done it on the Ramlila Maidan or the Kaban Park. This is what the Supreme Court did. They ordered a floor test when there was no floor. Let us not forget parliamentary conventions and the law relating to parliaments and the Constitution, which the Supreme Court must be well aware of. There is no house until the house is constituted after the election. The speaker, the oath is administered by a pro tem speaker. The speaker is elected. The head of state addresses what is known in England as the speech from the throne, the opening address to the house. Only then is there a house. Only then can members open their mouths. And a vote of confidence is perhaps one of the greatest things that members exercise as square members. How can we exercise that right without a floor, without the house being there? The Supreme Court totally lost sight of this, and the judgment is absolutely wrong. Now, don't have the slightest doubt about it. It produced a good result. That's a different thing. That's not the question. What the court should have done is, yes, they should have ordered an immediate test after the speaker is elected and the governor addresses. That you have a floor in constitutional parlance which the Constitution recognizes. This was as good as you can have it in your house. You can have it on the road. That was all the floor that the Supreme Court did. Of course, it didn't matter at all because the Chief Minister resigned. The political process took its course. That is why I said there are certain things that judicial process cannot interfere. It will be a failure. Let us disabuse ourselves that judiciary is a panacea for everything. Not at all. And many relations are political. We must work it out. Sometimes we fail. That's the play of democracy. It's not ruled by the judiciary, thank God, it should never be.
So now we come to another important question that was raised in Shivraj Singh Chauhan versus Speaker Madhya Pradesh Legislative Assembly, particularly in terms of the governor's role in calling for a trust vote. So to what extent do you think this decision is faithful to the principles that were laid down in S.R. Bommai versus Union of India?
I think there is no conflict between the two. I have always said, not with reference to this case, but the general thing, including what happened in 1998, or rather 1999, that the president or the governor is taught to have a surveillance over the majority. Minority governments are accepted in parliamentary democracy. Not for a day. Minority governments for a whole term are not unknown. Neither is it unconstitutional or illegal. It is on important issues that they must have the confidence of the House. It's not a day-to-day affair. And that is why I always said, digressing for a moment, President Narayanan's directive to Prime Minister Vajpayee to seek a vote of confidence when Jayalalitha's ADMK withdrew support was constitutionally, morally, politically untenable and totally wrong. Why? Parliament was in the midst of the budget session. The finance minister had presented the budget, the debate on the budgets was going on. What greater confidence is required in a government than its budget being passed? It is well settled that if the budget is not passed, the government has to resign. So that was already a debate for a vote of confidence. In the midst of that, the president asking this was, in my respectful view, absolutely unwarranted. But in Shivraj Singh Chauhan's case, the facts, a number of legislators had already given their resignations. The numbers had come down. The government was not advising the calling of a session. And in such circumstances, I don't think it was wrong on the part of the governor to call for a session and ask the ministry to get a vote of confidence. And that's exactly what the Supreme Court has also ruled in that case. Bommai is, of course, the general rule, but then, as facts emerge, you would have to face those situations.
Now we come to another comparatively recent conversation, an ongoing conversation, which is on assent to bills passed by the state legislatures. And we have seen two significant cases emerge out of this topic. And the first decision was State of Tamil Nadu versus Governor of Tamil Nadu, where we have seen that the Supreme Court has sought to exercise, to guide the exercise of powers by the governor under Article 200 by effectively laying down timelines for the consideration of bills passed.
No timelines were laid down. No timelines were laid down. Judges and lawyers have said this are ignorant and have not read the judgment. Sorry. No timelines were laid down. I think we must start from ABC to read. Pardon me. This has been one of my favorite topics for the last 15, 16 years. I have worked on this. We begin with, again, that we are in a parliamentary system. 1. 2. Legislation is the expression of the will of the ultimate sovereign, the people, expressed through their elected representatives, the legislators. 3. There are no parallel centers of power. The president or the governor has no power. Let us be very clear. And let me, at this stage itself, say another thing. No one under the Constitution has any power. Be it the executive, the legislative, judiciary, everyone has functions and duties. The moment you forget that, you commit all the sins in all the three ways. You have no authority, you have functions to discharge, duties to perform. Who are you? The president is our first servant. That's all. We are not under a monarch. We are not subjects. We are citizens of a republic. That should inform everything that we say and do. Well, that's a very general observation. 200, it has been very clearly said in the Constituent Assembly debates, in various judgments, it's not in the domain of discretion. It is not 163. It cannot be if you accept the fundamental principle that we are a parliamentary democracy, legislation is the expression of our will. It's the governor to say no to that, or the president. Then why do we need them? As Dr. Ambedkar said, just a ceremonial device on a seal by which the nation's decisions are made known. And please remember that even for a monarch in England, where you still have the language of the prerogative, the royal prerogative, etc., royal assent has not been refused since 1707 during the reign of Queen Anne. So that is 320 years. What then to talk of a republic? So, 200, the Constitution itself has very beautifully structured it. The problem is people in different positions seem to have their own views. The governor or the president, who in the case of a money bill, there is no choice at all. Naturally, because money bill has to be passed and the country has to function. They can return it to the legislature with a message. The legislature then considers it, either accepts it or does not accept. This is exactly the purport of what Prime Minister Asquith mentioned in the memorandum to King George, be it the ministers or the legislature. And once it is passed, he has to accept, reserving for consideration. The Constituent Assembly debates, in fact, Alari's opinions, even the question of reserving for dissent or refusing assent is only on the advice of the Council of Ministers. Where do you refuse assent? Where the cabinet advises you for certain other reasons. After the bill is passed, public opinion may be against the law, or they have other reasons. They feel this should not become law. The cabinet advises that you don't assent. So that refusal of assent, that function comes in there. You have a typical example in the 50s when Parliament passed the appropriation bill for PEPSU, for the reorganization. By the time it reached the president's desk, then there was president's rule in PEPSU. By the time it reached the president's desk, president's rule was revoked, which means Parliament ceased to have power to do that. And therefore, the Union Cabinet advised the president not to assent to that. So these are situations where refusal to assent comes. Reservation for the consideration of the president is also to be done on the advice of the Council of Ministers, except the second proviso to Article 200, where the legislation affects the High Court. So these are very clear that refusal of assent is unconstitutional, is a passage in D. Smith, which was quoted by the Supreme Court in some Sher Singh's case. Therefore, the governor not giving assent would really mean you're a parallel center of power. The Constitution does not envisage that. Of course, you could always talk to the government, try to, put in your views. No one says no to that. In fact, constitutional provisions themselves speak of that, the exchange between the Council of Ministers and the President of the government. having passed that stage, it is not even for you to sit in judgment over the constitutionality of that law. You may feel that there are some flaws. In your opinion, that's the governor's opinion or the president's opinion, it may be unconstitutional. The courts will decide it when it comes before them. Otherwise, you are virtually usurping the function of the judiciary. The governor reserving bills for the president's consideration, left, right, and center, I would say is also an abdication of his functions. He is expected to assent, not push it off to Delhi. Except perhaps, even there, the settled position is he must do it on the advice of the cabinet. See, matters in concurrent list where you feel that there may be some conflict between a union law and a state law, possibly. But even that, if the conflict comes, the state will face it in court. It is not that you can't do it. It's only that to the extent of the repugnancy, the law would be not that. So, Tamil Nadu, Justice Pardiwala's judgment, of course, it has some flaws, broadly laid down only this. Coming to timelines, the court, please bear with me. The court did not lay down timelines. Please see paragraphs 237 to 241, if I'm not. What did the court do? And if you ask me a question whether the court can lay down timelines, the answer is clear, no. No court can lay down timelines or a power should be exercised by judicial fiat. It has to be only by statute. There's no trouble about that. But the fact is, because everyone is done, sorry, and I'm repeating it again. Lawyers arguing and judges writing have all been talking of timelines being laid. Sorry, timelines have not been laid. As the judge himself very clearly says in these 4 paragraphs. We come to the basic premise that all state action has to be reasonable. I think that's too well settled now. In 2026, we don't have to. Way back in the 70s and 80s, this is. And the president of the government is also state, he is not someone else. So all action has to be reasonable. All action has to be reasonable, also takes within it the concept that it is to be exercised within a reasonable time. That's also well settled, right from the 80s. In a code of judicial review, how do you really pronounce upon whether it has been exercised reasonably? It must be exercised in a reasonable time. So you have some yardstick, some measure, whether it is 24 hours or 24 days or 10 years, whatever. Some yardstick has to be. And it is in that context that Tamil Nadu case, Justice Pardiwala spoke of those 3 months. And again, 3 months are not from his hat. 3 months, apart from the Kunchi Commission and the forget these commissions. 3 months is in the memorandum of February 2016 of the Union Ministry of Home Affairs. Same is political dispensation ruling even now. I'm not talking of politics. All that I mean to say is it's the same people. So it's the office memorandum, the Union Ministry of Home Affairs, I forget the exact date, it's February 2016, as to how these functions must be. Some timeline has to be fixed. It's only that the judgment said. So if you do it within 3 months, it would be considered reasonable. Again, it is not a law of limitation. What happens if you do it after 93 days? It does not become bad. While if it is a limitation, it will even 1 hour after that would be illegal. There's a broad time frame to say if you go within this time, it would be reasonable and stand the test of judicial. That's all what the judgment did. And to find fault with that, I'm afraid, if I'm not using harsh language, is stark ignorance at every level with utmost respect.
So perhaps when we read the judgment, this is something that the court time and again tries to justify by referring to these important documents in particular.
Sorry?
It talks about the documents in particular. It talks about the judgment of the Supreme Court in Kesham Megachandra Singh as well, where the same 3 months yardstick was laid down. And also when it tries to justify that the 3 months time period does not necessarily amount to amending the constitution.
Definitely not. Definitely not. Yes. And 3 months doesn't mean, if it is, as I said, if it is 4 months, what happens? Nothing happens. On the facts and circumstances of that case, it may still pass muster. It may not pass muster even after 1 month. 3 months is not a limitation. There may be situations where the court can say even 30 days does not pass muster.
So can we in a way call it a judicially manageable standard that was identified here?
Yes, why not? On a case-to-case basis. Otherwise, please see, you must always look at the result. You are totally defeating the will of the people. Will of the people may be good or bad. I am not for one moment saying that every law that comes out, is the best. It may be foolish, but you have that famous statement of Chief Justice Stone, then Justice Stone, Harlan Stone, in US versus Butler, for the removal of unwise laws, appeal lies to the ballot box and the process of democratic government, not to the court. It's quoted in 1974 Supreme Court 497, Collector of Customs versus Murthy Matchworks. So, these principles should always inform our understanding and exposition.
Sir, I think now coming to one of the most important topics, and you've written extensively on this as well, the recent presidential reference, which involves the same set of questions. So what would be your take on this?
Fortunately, it's only an advisory opinion and nothing more. But even then, it has done a great disservice to the country. Earlier, it is shot down and buried in the dustbin of history. The better for this nation. And I'll tell you why. Great respect. It is bristling with flaws, but to take the crown. We have already talked about. One is where they still say governor's discretion. In a parliamentary system, one can't understand it. I've talked about it extensively. The second is Article 200, where they say even after the bill is passed, presented to the, bill is returned to the legislature, passed again and presented to the governor, he still has discretion. I think that's the limit of perverting both logic and language. The language is very clear. He shall not withhold assent. Suppose if you want to write it in your own image, well, you can rewrite the Constitution. They have done it many times. And that's why I've said this is the case of the court desecrating the Constitution. Palkiwala spoke of the Constitution being defaced and defiled by Parliament. Other wings have not lagged behind. And then you also have the cardinal sin of considering Justice Krishna Iyer's judgment in Samsher Singh as a dissenting judgment. It's a concurring judgment for himself and Justice Bhagwati. And the other 5 judges did not demur on what he said. There's no conflict between the two. And Krishna Iyer's proposition has been repeated by other constitutional benches later. MP Special Police Establishment case in 2004, R.U. Mehta's Gujarat in 2013, and many others. And in the light of all this, in the teeth of all this, to say that Krishna Iyer is a minority view, I think you must know how to read judgments. Because if you wanted to write something in a particular way, God bless you and God bless us, the country. That's all. Only yesterday I have just finished editing that article for the Commonwealth Law. How the Supreme Court has turned the Constitution on its head.
All right. I think we do not want to, conclude this discussion, considering that it's an amazing learning process about the nuances of the Constitution, particularly in light of the gubernatorial position, and how interesting this entire office is, and the kind of questions that it kind of give rise to. But I think every good thing comes to an end, and so here we shall conclude. And I would like to thank Sir for his thoughtful insights on this very, very pertinent issue that every student of law must take up and try and comprehend in a very serious manner. And we have seen today how the office, it sits at the intersection of constitutional design, the federal balance, the political practice, kind of making it one of the most fascinating institutions in the system of governance in India. So thank you so much, sir.
Just one word again. I'm sorry. Just one word. It is also settled that advisory opinion is not given when questions of law are settled. It's only when there are doubts that the court steps in its advisory. So this was a reference which the court should have returned an answer, because answers to all questions were available in earlier judgments, in Constituent Assembly debates, in conventions. And of course, some of the questions I was even tempted to say that they were framed were virtually like, one of the questions perhaps could have been, should we abide by the Constitution? The tenor of the reference was nothing less. And the answers were equally good, like saying the sun rises in the west and not the east. Thank you.
Right, sir. Thank you. Thank you so much, sir. I thank all our listeners for joining us, and I genuinely hope that this conversation provided a very, very deep insight, into the constitutional dimensions of the governor's role. I would now like to thank our student coordinators, Sansi, Aditya, Saurabh, Carlo, Rini, and Divita for their contribution. And again, we look forward to another episode very soon. Till then, we look forward to having you once again, sir. Thank you so much, and we are genuinely looking forward to hosting you here on campus very soon. Thank you so much, sir.
Thank you.
Thank you, sir. Thank you.